Basically, I salute you all, and today's topic of concern is looking at the administrative law remedies. Those are the remedies that today we are going to look at. And basically what you have to know, or what you have to bear in mind about the administrative law remedies, they are invested, or they are put under Section 36. Section 36 of the Judicature Act of the Republic of Uganda. And some of them we have what they call, we have mandamus, certiorari, injunction, prohibition, injunction, among others. And in line, when we add Section 36 clause 5, it mandates that court is also empowered to award damages in addition to the above remedies which I've speculated above. And basically to note that, which means or which implies that automatically damages is also an administrative what? Law remedies. I'll first with the judicial remedies. One of it which is prerogative orders. What do I mean by prerogative orders? These are orders. They are invested under Section 36, subsection 10 of the Judicature Act. Sorry, I may be using clause, but it is already subsection. So Section 36, subsection 10 of the Judicature Act provides for those prerogative what? Orders. And in addition to the case of Lex Uganda Advocates and Solicitors versus Attorney General, where court said that the prerogative orders are remedies for the exercise of power by those in public offices, and they are available for a private personnel in challenging the decision of a public authority. So basically have that, not that. And we also have another remedy of certiorari. What do I mean by certiorari? So basically this means quashing a decision made by an administrative officer or a body or any authority by the High Court. The High Court is the one that provides this remedy of certiorari. You get? So it is when you read the case of Farida Katerega Zarwango and two others versus the Deputy Registrar High Court. Under that case, the applicants realized that the applicants asked for that remedy of certiorari, and the court said that according it related to the Hasbury laws of England, you get, whereby the statutory laws lies on the application of a person aggrieved to bring the proceedings of an inferior tribunal before the High Court for review, so that the court can determine whether they can be quashed or not. You get? So basically that case provides that essence. Then we have prohibition. Prohibition and certiorari, most of them move together, but regardless they are different. You get? However much they are moving together, but they are different. Prohibition, basically they prohibit something to happen. You understand? That is also an administrative law remedy. They prohibit something that is about to happen. You get? So basically there is the good case related Ara versus Electricity Commissioner of 1924. Under that case, the body having legal authority to determine questions affecting the rights of subjects and having the duty to act judicially basically used that order to prohibit. You get? To prohibit because it didn't have that jurisdiction. You get? So it was prohibited from hearing from such matters. And some of the key elements that are considered under prohibition, we have what they call excess, stroke abuse, or failure to exercise discretionary powers. And we also have what they call errors in law, fraud and perjury. You get? Where the waiver. What do I mean by waiver? It's like a negligent, to negligate to bring any act of the foresaid irregularities before court at the time of hearing. So all of that you can be prohibited. You get? You can be prohibited towards the same. You can be prohibited. So, and also delay. Once you delay, Sometimes you can be prohibited to bring your matters before court. So that is what they call prohibition. Then we also have mandamus, which can also mean mandatory injunction. What do I mean by mandamus? It is also provided under Section 36 of the Judicature Act. Mandamus is like an order directing an action to be done or taken. It is an order made by court, ordering the action to be what? To be done or to be taken. That is mandamus. And the good case that I can use there, the case of same construction company versus Rukunjiri District Local Government of 2010. Basically here they say that mandamus is a prerogative writ to a person or body to compel performance of a public duty. And some of the ingredients that they highlighted for this order to be granted, one of it is public duty owed to the applicant. You must have a public duty that you owe to the applicant. Also, the applicant has a legal right to perform to the performance of a legal duty. It must be a public duty. The legal right must be in the applicant himself. You cannot sue on behalf of the other. Your right must be within yourself. The application must be in good faith. If application is for the third party, then it shall not be granted. You get? So realize those are some of the elements that are considered in awarding the order of mandamus. Then there's a good case of Shah versus Anthony General, 1970. Shah versus Anthony General realized that the applicant had obtained a judgment against the government for shillings 67,500 interest and costs. The government failed to pay, so the applicant brought the motion in court so that court can award an order of mandamus to the responsible officials, ordering them to make a payment of his of his money, of which he realized that the court held that the mandamus could issue it to the treasury officer of accounts of the government, compelling him to carry out the duty to pay the cost upon him, subject to Section 20, Clause 3 of the Government Proceedings Act. You get? Because government had failed to pay. So the mandamus order was made to the officer, to the treasury officer of the accounts of the Republic of Uganda, ordering him to pay the applicant. Then we also have another administrative law remedy of habeas corpus. Habeas corpus is provided under Section 34 of the Judicature Act, although even the Constitution, Article 44, Clause D, also provides it. So, and also habeas corpus, we all know the case of NG versus Joseph Tumushave provides for that remedy. And here we also have the case of Mulembi Fred versus officer in charge of Chico government prison and 3 others. The habeas corpus was a key ingredient to that issue. It was key. So basically, note that in mind. That is the habeas corpus. Habeas corpus basically it means that you must be presented to court, whether dead or alive. You must be presented to court. Then we also have another administrative law remedy of injunction. Injunction here is where a party is required to do or to refrain from doing certain acts. That is injunction. You are refrained from doing certain acts. We have the case of Geila versus Sassaman, Brown and Company. That's where the court held that for an interim injunction to be granted, it must be shown that the applicant has a prima facie case. Understand, with the probability of success for you to be given the remedy of injunction. Then you also have administrative law remedy of damages. Damages, they are provided under Section 36. We have seen there is a case of Benedictum CC versus AG, provides for special damages. Then we have what they call declaration. What do they mean by declaration? So basically, declaration, another thing what you have to know or what you have to place in mind is that for declaration is also another administrative law remedy, which implies that it is like a judgment of a court pronouncing to the world the true position on the issue before court. Realize that a court can come out and declare that the company of so and so is corrupt. You get? So it's like that fundamental judgment towards the same. Because there's a famous case of the Russian Commercial and Industrial Bank versus the British Bank of Foreign Affairs. Realize under this case it was held that for that order of declaration to be granted, the question asked must be a real question and not a theoretical question. And the person raising it must have a real interest and must be able to pronounce a proper contra or contradiction, so are the same. Because it is risky. Once courts declare something, which means it portrays something else. It acts, if it is not true, which means it has brought consequences to that company or government. So you have to bear in mind, you get, for a declaration, it's like a pronouncement on something. It was, for example, the court can declare the police of the Central Police tortured someone, or the Central Police did someone. The Central Police prohibited the National Unity Platform from carrying out its right of of partisan. So that is declaration basically. Then there is also another administrative remedy of a judicial review. Judicial review is under section 36 clause 10 of the Judicature Act. Judicial review. Basically here, this is where a decision that is made is taken to court for a review, either to declare the decision that is not valid or to make it invalid, to review. In case there was procedural ultra vires or there is a misuse of discretionary powers, anything. That's why some of the decisions are taken for judicial review. You get? So those are some of the administrative law remedies basically. Okay, thank you for listening.